Okay, well, welcome everyone to our last legal philosophy seminar of the term. We're really pleased today to have with us distinguished professor from the NYU Law Faculty, Professor Mattias Kumm. As I said, he's a professor of law at New York University, where he's also the director of NYU's joint LLM JSD program in international and comparative law. He's also been a visiting professor and John Harvey Gregory Lecturer on World Organization at Harvard Law School, Commerce Bank visiting professor at Bucerius Law School, in addition to teaching at various and lecturing at various leading other universities worldwide. His research and teaching focuses on foundational issues in global, European and comparative law, international law, and legal philosophy. He's published numerous articles in leading international and European journals on a range of issues in European and international constitutional theory, especially work on constitutional conflicts, as well as publishing several book chapters in leading text on constitutionalism beyond the state, including the paper that was made available for today's seminar, which is also just recently published in a collection called Ruling the World, Constitutionalism, International Law and Global Governance. So today's format is going to be a little bit different. We're just going to have Professor Kumm give us his paper, and then we're going to go right into questions for discussion to maximize our time to debate and learn a bit more about Professor Kumm's work. So please join me in thanking and welcoming Professor Kumm for joining us today.
Thank you very much. The topic of my paper is the idea of cosmopolitan constitutionalism, and the way that I'll proceed is I'll just first say a little bit about constitutionalism as an idea, as it underlies the idea of cosmopolitan constitutionalism, and then develop an idea of democratic statism, which I claim underlies or is able to reconstruct a significant part, only a significant part, but a significant part of arguments and legal thinking used by lawyers and courts, both on the national level and on the international level. And then I'll contrast this interpretation of constitutionalism, so constitutionalism as democratic statism, with what I will propose as a more persuasive way of understanding constitutionalism, and that's cosmopolitan constitutionalism. And why that matters and what consequences are to be drawn from that I'll also illustrate while I'll engage in the description of these various ways of making sense of constitutionalism. So to begin with, if somebody presents an idea of any kind of constitutionalism, what is it that you're actually presenting? Or what is the idea of what are the central features of constitutionalism? Now, in a broadest sense, the Constitution just describes the basic principles and institutions governing the exercise of public authority. In this very broad sense, constitutionalism and the study of constitutions has been part of Occidental intellectual history since Aristotle, and there's nothing new about it. But constitutionalism, as I will use it, is constitutionalism that can be traced back only to the 18th century, perhaps late 17th century, but probably 18th century, paradigmatically the French and the American revolutions. And what is distinctive about constitutionalism in this narrower sense is that law and the exercise of public authority is no longer thought of as at least also in part involving, as Hamilton says in Federalist number 1, accident, force, or the quirks of history, but should be conceived of as the result of a deliberate choice found to be acceptable by free and equals. And this very general idea is then typically fleshed out, and today arguably is the dominant ideology, in terms of a commitment to the rule of law, democracy, and human rights. So if law makes a claim to legitimate authority, then if we're talking about a constitutional understanding of law, as I claim for the most part modern we do today, both domestically and internationally, then what that means is that this claim to legitimate authority is only plausible if we can show how existing law can somehow be justified with reference to the idea of the rule of law, democracy, and human rights. Now, that's not very specific yet. These are very abstract ideas, and one can think of debates in the last 200, 300 years as being debates about how to flesh out what that exactly means in more concrete institutional and practical terms. But it's this vocabulary that we're using. These are the standards that are, at least by the hegemonic mainstream, understood to be the basic language for the justification of law's claim to legitimate authority. So what I want to do now is to flesh out one way, one paradigm, I call it, or a cognitive frame, that attempts to make sense of the legal world and give more concrete shape to these ideas, to reconstruct the actual practice of law. And it's a conception of constitutionalism that I call democratic statism. Now, democratic statism is a conception according to which the idea of human rights, democracy, and the rule of law are worked out in the following way. And of course, this is schematic, simplified, and reductive, but it's nonetheless, I hope, illuminating. It's the following. So first, we have national law. National law is the paradigmatic form of the law. And national law is justified in terms of a constitutional project of self-government. We have the Constitution as the supreme law of the land, deriving its authority in some way or another from we the people, that continues to self-govern itself within a democratic process constrained by rights guaranteed nationally in some way or another. So that's a very, I think I've provided a relatively mainstream description of liberal democratic constitutional self-understanding to some extent. Now, how is that related? Now, how does international law come in this picture? International law, if ultimately the legitimate claim to national constitutional authority, which establishes the supreme of the law of the land, if that's legitimate because of we the people as the ultimate source of authority, then international law is legitimated through the idea of the consent of states. So the regulative normative ideal is that all the republics, all the liberal democratic republics, can create international law to coordinate their behavior with one another. But in order for it to be legitimate, you need the consent of these states. And thereby, you tie back the authority of international law ultimately to an act of we the people mediated through the national institutions of each respective state. So international law is conceived of as being based on the consent of states. Now, in a variety of ways, international law within this model is always the poor stepchild of the core paradigm of law, which is national law. And it's always the stepchild for reasons that have historically ebbed and flowed, but it's possible to distinguish between three types of reasons as to why international law is somehow not quite the same thing, is somehow less than law properly so called, or at least law in the domestic sense. Now, first, historically, there were conceptual arguments. If you believe that law is the command of the sovereign, then, of course, there's a problem with international law because there is no such thing as a sovereign on the international level. And even if you don't believe in an Austinian type of theory of law, the very idea of sovereignty that is associated with the state seemed, at least to some for a time, conceptually difficult to square with being subject to legal obligation. For some, particularly in the late 19th, early 20th century still, the very idea of sovereignty was incompatible with the idea of being subject to another authority, the authority of international law. Now, those claims are kind of off the table. They're no longer regarded as interesting, jurisprudentially not particularly convincing, conceptually not particularly convincing. So that's no longer the core concern. But we have different types of concerns that tend to reify international law status as a less important and somehow problematic category of law. So first, there are arguments relating that we might call in a very broad way realist, that suggest that, not for conceptual reasons, but for empirical reasons, international law is a project that's unlikely to really get off the ground, because sovereigns will generally follow their national interests, and so international law is either irrelevant and will be ignored, or it is epiphenomenal and just reflects an equilibrium of interests that, in principle, could change at any particular point in time. Law doesn't tell you anything about how states will behave. Sometimes it might provide some kind of signal that may be of relevance to some degree, but this is not really authority in any meaningful way. So that's a realist type of critique of international law that in a modest and more sophisticated version still has some play today, even though it also has to be said that predominantly today there's a rich literature that describes how and why it is how it's possible and why it is the case that, as Henken famously stated, most states practically all states obey practically all of international law practically all of the time. So that's empirically, for the most part, believed to be true. And if that's true, then the real question is only how come? It seems to be strange, if you're in this conceptual universe, to find states actually complying so much with their international obligations. And so you have a rich set of theories that try to explain why it is that international law, notwithstanding the absence of a sovereign on the international level, notwithstanding the absence of armed forces, police, compulsory jurisdiction, the types of things we associate with the state being absent, why nonetheless it is the case that on the whole and for the most part international law is effectively complied with. That becomes a puzzle, and that's a core interest of contemporary literature, both in political sciences and the law, to explain why that's the case. So doubts about compliance and efficacy are another reason to be within this paradigm to be skeptical of international law. And thirdly, there are reasons relating to the legitimacy of international law in much of its contemporary form. So if it's true that ultimately within democratic statism, authority comes from we the people, and thereby international law can only be legitimate because it's based on the consent of states, then there are a number of features of contemporary international law which seem to be deeply problematic. In some sense, we might say skepticism about international law has today taken a democratic turn. Most of the challenges nowadays are no longer by realists, even though that strand still persists to some extent, but they come in the form of challenges to the legitimacy of international law. And then most of the authors that write in this vein point to the following kinds of phenomenon. First, they point to the idea of customary international law, which has increasingly been understood no longer to really reflect the kind of long-standing, widespread practice that can be understood as operationalizing an idea of implied consent, an old classical conception of customary international law, but seems to be much more aggressive, a quasi-legislative decentralized procedure which doesn't require the kind of consent or the kind of an idea of, it no longer requires reconstruction in terms of implied consent. It seems to be less. There's pressure-cooked international law. Customary international law becomes a form of decentralized legislation. So that's regarded as a problem. And secondly, what's also regarded as a problem is the prevalence of international treaty regimes, which, even though based on state consent, develop a life of their own. Institutions are established, and these institutions or courts then go on to make decisions and over time follow path-dependent trajectories which lead to the generation of new law which is significantly removed from anything that could plausibly be reconstructed as part of the original will of those who consented to the treaties. So that's another problem if you think it's important to tie back concrete international legal obligations to the idea of state consent. And furthermore, there are conceptual categories that it seem deeply problematic. The idea of jus cogens, which suggests that there are some things out there which are simply not susceptible to change through state consent, treaty, etc., but seem to be beyond that in some way, as a normative core, which is beyond beyond that which states can something beyond what states can change, and the idea of obligations erga omnes, which suggests that each state needn't have agreed to something to nonetheless be somebody that you owe something to as a result of having a certain kind of legal obligation. So the contractualist model, the consent-based model, is to some extent no longer very useful to reconstruct in normative terms much of what is going on in international law. And within the democratic statist paradigm, that's a sign of crisis. That's a challenge. There's a legitimacy problem because of that, because it can't be constructed in that form. Now, is this way of trying to make sense of the ideas of human rights, democracy, and the rule of law, is democratic statism a plausible way of interpreting the idea of constitutionalism? What's wrong with it? And I want to develop the idea of cosmopolitan constitutionalism to begin with, as a kind of critique of the model of democratic statism. Now, first, what somebody with a cosmopolitan constitutionalist sensibility would immediately remark is that all these debates about compliance relating to international law are skewed in an interesting way. The presumption is that there's something really weird and important to explain. There's a puzzle. States seem to obey international law most of the time. Sometimes they don't, but for the most part they do. And that seems to require explanation. Now, perhaps it does, and I find it perfectly plausible, particularly from a sociological or political science perspective, not to simply assume that when there's law out there that it will be complied with. But the interesting thing is that there's no symmetrical interest in domestic practices. There's good reason to ask, why is it that domestically we believe that states are actually such stable and for the whole and for the most part entities which have no problems in securing the effective and uniform enforcement of the law? Empirically, actually, it turns out that there are huge problems. And not only is it the case that since the 90s, there have been more problems of state collapse and failed states than there has been instances of interstate warfare, for example. But it's also more generally, and revolutions and coups and all of that. But beyond that, it's also the case that even if you have a reasonably stable political system, problems of corruption, problems of non-compliance across wide areas of certain areas of the law are endemic, a normal part of most domestic practices. So what this suggests is that if we think about how domestic law actually works, that we might revisit the idea that the pure existence of courts that have compulsory jurisdiction and people in uniform that are either part of the army or part of the police are necessarily the key element that makes that removes all problems of enforcement. I think there's something fundamentally wrong with that idea. That would require significant longer development. I won't be doing that here now. I just want to very briefly point to the fact that the moment that you have hierarchies of armed, mostly men, but not only men in uniform, then of course you just create additional problems. Because how do you know that they will follow the orders of the civilian who claims to be calling the shots? And even if you just focus on the military hierarchy, how do you know that the guy who sits behind a big desk in Washington is going to call the shots, as opposed to a battle-proven, popular young colonel that might be tempted to take over? That's a huge problem. It's been a huge problem in many countries, in many parts of the world. Young, ambitious officers that disregard the hierarchy and establish themselves as new. So there are lots of problems connected to the idea of police, the army, problems that are created by these institutions that themselves are puzzles if we start off with a rational interest model for trying to explain social behavior. Now, I'm not saying of course there is very specific literature on all of these problems, but what is interesting is that those who study the international law problem are completely unaware of that and uninterested in that literature, and believe that they're studying a problem that's somehow endemic and special to international law. And what I'm suggesting is there is actually probably nothing all that special about international law specifically. There are all kinds of problems in special areas of the law in international law, as there are in special areas in domestic law, connected to specific institutional features, particular social and cultural background issues. So questions of compliance ought to be part of the things that lawyers should generally be concerned about. A law is, in some sense, a brittle thing. But it's also significantly more robust on the international level than is widely believed, and more brittle on the domestic level than widely believed. So that's the first point from a cosmopolitan perspective. If you think of those two together, that you might want to make and then explore. Now, I haven't made an argument. I've just pointed. I've pointed to a research agenda to some extent. But now let's go to the normative side. So if the efficacy arguments are arguably ones that are given too much credence and thought to be too important, more important than they deserve to be, what about the normative claims relating to legitimacy of international law? Now, one of the things that I find fundamentally flawed, really fundamentally flawed about the democratic statist model, is that it takes as a paradigm of legitimacy the setup of a well-working, let's assume, well-working liberal democratic state. So the idea is that if you have a well-working liberal democratic state, then we know what legitimacy means. We know this is legitimate. And that's, in some sense, the standard that we'll want to, in some way or another, we might revise it somehow, adapt it to a different context, etc., but it'll be the starting point, the baseline for thinking about legitimacy beyond the state. Now, what exactly is wrong with that? Well, one of the things that's fundamentally wrong with that is that it's audacious to claim that a well-functioning, well-working liberal democratic state can be said to be legitimate without paying any due regard to the transnational context of which it is part. There are legitimacy problems inherent in the very idea of having separate states, questions we need to ask about that. So why is that the case? Why is it the case that we can't say that at least with regard to the establishment of a well-run liberal democratic state, we've answered the legitimacy problems that it raises? Well, the answer is that the establishment of a state creates negative externalities that create burdens of justification. Now, what are those negative externalities? What are the claims that others could raise? There are a number of them. Here's one. If you have a structure, a Westphalian structure in which territory of the earth is divided up in different states that claim, prima facie at least, absolute control over the territory and the jurisdiction to legislate over that territory, then you've created relatively centralized power structures that in turn lead to significant dangers for others, weaker states perhaps, so that there's a danger, in principle, structurally in such a system, relating to warfare and violence. And that danger exists on the one hand externally, so the idea that other states may be invaded or coerced, etc. So the classical Hobbesian problem, the external Hobbesian problem. But it also concerns the problem of protecting individuals against the created Leviathan. So arguably there is a duty owed by the wider community to the citizens of a state who might, under some circumstances, feel imprisoned by and weak and helpless towards the relatively centralized authority of a state. And an international system that reinforces or that permits such a structure is arguably under an obligation as a result of having supported and permitted that type of structure. So there are externalities on the one hand relating to fears relating to security and the use of force, the external Hobbesian problem, and then there are this is the internal problem of creating a dangerous situation for citizens in the state. But that's not the whole story. Even outside of the domain of war and coercive activities, think about other kinds of negative externalities. Think of, for example, quite mundanely, a state engaging in certain policies which lead to carbon dioxide emissions, which in turn lead, as we are now relatively certain, to anthropogenic global warming, which in turn leads, let's assume, in some countries at least, to significant costs, massive relocations of millions and millions of people. Some Pacific islands will disappear. We have the phenomenon of sinking states. So those are externalities. That creates a real problem. This is just one particularly dramatic example, but of course, outside of the dramatic area of climate change, we can kind of scale it down and think about states positioning nuclear power plants on their borders or using rivers that flow their country into the next in a certain way, creating negative externalities. So there are all these negative externalities, and the potential and the reality of all those negative externalities. And so the question whether or not a particular state or a state establishes legitimate legal structures depends to a significant extent on the structure of the international system which it is part of. The question is, does the international legal system that it is part of, is it able to effectively address these types of problems? And only if it can, and if it does, can one say that a Westphalian system, of which a liberal democratic state is a part, can make a claim to legitimacy. Without it, it can't. There's an inherent legitimacy deficit in status structure unless we can additionally say something about the structure of the international system of which it is a part. What that means, okay, and there's one more externality that I at least want to put on the table because it is central, I think, before I move on. And that concerns the position of people, the position of individuals who, in virtue of finding themselves born into a world in which there are states which make a claim to have exclusive control over their territories, they are kept out of those states. If you start off with the assumption that we're this is the way that Kant thought about it. You start off with the idea that we all populate the surface of the earth, and we share the surface of the earth. Then then something happens the moment we say we now divide up what we share to begin with, and create entities that, in a property-like way, have effective control through territorial jurisdiction over their territory. And like property, you can exclude others. And that's one of the basic principles of current international laws. It's still the case that, with very few exceptions relating to refugees and asylum law, important exceptions, states can pursue whatever immigration policy they deem fit. And that means that if you want to go somewhere beyond your state, you have a right to leave your state, but you don't have a right to go anywhere else. You may be lucky if you have a decent education, you're part of the professional class, or if others need your labor because you provide it more cheaply, then you might get a working visa, you might get out, but maybe not, depending on what your position is and depending on what the policies of the other countries are. And that's an externality. That's a problem. That's a normative problem that requires, at the very least, justification. Now, what the solution to this problem is, well, that's a complicated question. But the point is we need an international legal, it's important to have an international legal system that addresses these issues in some way or another, that allows for these issues to be contested, negotiated, and decided upon. There are duties of justification that are owed that have to be substantiated in procedural and practical institutional terms. And a state just by itself, just by saying, look, we are establishing a working democracy and respect the rights of our citizens and those who live on this territory, is simply not enough to provide that. Those who come, those who want to come, those who seek to come, they are too are owed a justification. And they're not being provided that by being kept out of the country by border guards. So that's another externality that raises these issues that, however you think of them, or whatever you think the right answer is, they need to be addressed in some way, and the international legal system needs to address them in a plausible way for the domestic system to be legitimate. So there are conditions imposed. There are conditions relating to the legitimacy of a Westphalian system. And those conditions have to be guaranteed by the international legal system, of which the national system is an integral part. So that's kind of that's a critique of democratic statism, and you see where it's going in terms of the development of a cosmopolitan model of constitutionalism. Now, to be very clear, where it's not going into the establishment of a world state. That would be kind of a democratic status solution writ large. So instead of just having lots of states, we then just have one centralized one. That's not what I. There are a variety of reasons, and not only those mentioned by Kant, for example, but also others, that why this is neither necessarily normatively attractive or, for that matter, politically feasible. So when I speak of cosmopolitan constitutionalism, it's not that. It's very important. It's not a statist vision of the global order. Instead, what it is a requirement to reflect about the legitimacy of legal and political institution within the cosmopolitan horizon. So it means taking account of externalities of established legal systems in the appropriate way, and helping to ensure that the legal system that any legal system that might exist contributes productively to the establishment of the conditions, the external conditions that would legitimate their practices. So there are not only internal legitimacy conditions that constitutionalism establishes. Cosmopolitan constitutionalism is characterized by the fact that it reflects both on the internal and the external legitimacy conditions of legal and political practices. Now, if you do that, what type of principles or what type of well, perhaps I won't even go there. I've said something about that in the longer article here. But what I'll do now instead is I'll point to a number of core concerns that might practically come into focus once you think about constitutionalism in this cosmopolitan sense. So, if within the statist paradigm we'll talk about enforcement problems relating to international law and legitimacy problems relating to international law because it's not democratic the way that national institutions are democratic. Within a cosmopolitan framework, we start focusing on completely different things. What we're likely to focus on there are two things in particular. First, you want to focus on structural deficiencies of international law which relate to its failure to ensure the legitimacy conditions for domestic practice. So the question is, does the international legal system, does it in fact provide the institutions, procedures, and structures that effectively address the negative externalities that I've mentioned with regard to the state system? So we might, for example, be wondering right now whether a system that ultimately requires questions of global warming to be addressed through the mechanisms of a multilateral treaty that ultimately requires all major actors to sign on, whether that's not the structural deficiency. That's not a very efficient way to address collectively as a global community questions of climate change, because it makes it impossible if you have. It's very plausible to have one or two or three powerful actors who make their own national cost-benefit calculus and say, for us, it's actually more effective to invest in addressing the consequences of global warming than to fight it ex ante. It's when we look at the costs and benefits of these two respective ways we could go, for us, we might come to the conclusion in the United States, perhaps, I don't know whether this is true, I've actually heard very different views on this, but let's assume it was true, that for the United States it would be cheaper and more effective, welfare enhancing nationally, to say we'll face the rising ocean levels and the climate change. All in all, it's cheaper for us to build a couple of dams on the East Coast and on the South Coast. And there'll actually be a benefit in Maine and some other countries where we can now, agriculture will pick up, more oranges will come not just from Florida but also from elsewhere. So all in all, it's a complicated equation, and all things considered, it's cheaper for us, it's best for us, welfare enhancing for us, to deal with the consequences of global warming rather than aggressively attack it. That could be, at least conceptually, it's possible for that to be the result of national cost-benefit analysis. And then you have, very likely, even in a well-working democracy, it's not implausible to believe that it's going to be politically quite difficult to get such a country, particularly if it needs a two-third ratification requirement in the Senate, to sign on to a significant treaty. And that can happen in a number of states that are necessary actors for effective countering of global warming to work. So that's a problem. That's a structural problem of the international legal system as it is. So what might be the problem of international law in some instances with regard to some issues is not what is going on right now, that it's too much and it's too far divorced from state consent. The problem may be the inverse. There's a legitimacy question related to the absence of certain kinds of institutions and the absence of certain mechanisms that address certain problems effectively. So that's a significant shift of perspective. It's all of a sudden what you're focusing on is no longer on what happens to be going on and raising your hands and saying, but where's state consent? Instead, you're worried about the legitimacy not only of international law but also of domestic law because of the absence of certain type of institutional features of the international legal order. So that's one major shift. The second major shift concerns the way we might think about domestic institutions relating to international law. So each constitution has provisions which determine how that state gives its consent to international treaties, for example, and how those international legal obligations are enforced. So both in the legislative process and in the enforcement, national institutions play an important role. And within the democratic statist paradigm, the pressure is always to ask questions and be skeptical about, for example, authorizing international institutions to do something. Do you want to really authorize processes which are not tied back to the national polity to make decisions that will then be binding? Shouldn't there be limits on that being possible? Huge debates, particularly in the United States, about the extent to which the empowerment of institutions, international institutions, is constitutional, or whether we should imply, based on democracy arguments, limits on the power, on the treaty power. Conversely, we might ask, well, what requirements, furthermore, we might ask, what requirements do we tie to participation in a treaty regime? So in the United States, for example, there's a 2/3 Senate majority that you need for a treaty to be ratified. And that, in realistic terms, is often prohibitively difficult. There are certain kinds of treaties which, exactly for that reason, were never ratified. Think of the League of Nations in the US context. Hugely important. Certainly it wasn't the only reason why the League of Nations failed, but it would have had more of a chance, arguably, of a major power, even then, such as the United States had played an active role, as the president at the time wanted it to. So instead of looking at the 2/3 majority as a plausible safeguard to ensure the democratic support for participation in international, we might look at it now and say this might be a barrier, and a deeply legitimate-wise problematic barrier to the effective engagement with international institutions of the kind that would then guarantee the legitimacy of domestic practices. So, with other words, the participation of states in the international legislative process through treaty making and the like become a concern, become something that you'll focus on, and you'll focus on in a particular way. Also, when it comes to the enforcement question, under what circumstances should international law be enforced? Within the democratic statist model, there's always the background assumption that because you can't be sure that sometime in the future there are still the respective political majorities in support of the original commitment that was entered into, you would want to have endorsement by the political institutions later on, and you don't want to have judiciaries to immediately get involved and enforce it. So doctrinally, this would go through a doctrine of self-executing treaties. Often a lawyer would say, this treaty is not self-executing, which means it won't be enforced by a court unless there is a renewed endorsement by political institutions, by Congress in particular, or perhaps by the president in some cases. But independent judicial enforcement is thought to be problematic because what is needed is a renewed endorsement by the political branches. And from the perspective of this wider integrative cosmopolitan framework, this might count as another in some instances, there's at least, you're loading the dice to consider at least the possibility that this again is an undue burden on the effective institutionalization of the conditions that make domestic practices legitimate. So, with other words, all the doctrines, the constitutional doctrines relating to the management of the interface between national and international law would be looked at from a very different perspective than they would be under the democratic statist model. So both how you think about the function and the purpose of international law, it's there to guarantee the legitimacy conditions for domestic practices. And it's not just about consent of state. More specifically, the doctrines relating to the management of the interface between the national and the international. That too would be looked at in very different ways. And in practice, this would lead, for example, when it comes to constitutional interpretation, to a push in quite a different direction. So, how you think about this, how you reconstruct the conceptually the legal world is not just going to be different in the sense that you'll look at it intellectually in some different way. It's also going to shape a variety of legal actors and political actors, a perspective on what they're doing as they're engaging in these practices. And that is likely to change outcomes. The pattern of outcomes is likely to be different. The kind of reasoning you'll engage in to be for or against a certain kind of reform, before or against a certain kind of interpretation of a legal norm is likely to be different. And that's likely to make quite a lot of difference seen as a whole. So in that sense, the cosmopolitan constitutionalism understood in this sense, ultimately as still geared towards the realization of a commitment to human rights, appropriate participation in the lawmaking process, and the rule of law, is what you also care about as a cosmopolitan constitutionalist. But you interpret these ideas within a very different framework, and that leads to a very different perspective on some of the basic questions of both international law and the domestic law of foreign affairs.
Typically we have a respondent for these papers, but today we don't because it's work in progress, so we thought that we'd all help Professor Kumm by progressing with him in his arguments. So I don't know, Mike, you were the original selected respondent. Do you have a few things to say initially, or would you rather we open to the floor?
My plan was to go right for discussion.
Perfect, okay.
Thank you, Professor Kumm. I sure enjoyed your extempore presentation. I'm the Jayasri Patian, a doctoral candidate here. I'm working on an enchanting topic which is sort of related to yours. I'm looking at the evolution of the United Nations constitutional assistance from a historical and post-colonial perspective. And I was very interested in the way you concluded and you said cosmopolitan constitutionalism is committed to the protection of human rights, rule of law. I have a preliminary question. Do you believe that all societies have their own conception of constitutionalism? Their own distinct concept of constitutionalism? Constitutionalism understood as limiting political power.
Well, to begin with, it's not just, at least with the conception that I've put forward here is not one just of limiting political power, it's also of constituting it,
Okay.
and in a certain way. And secondly, you are absolutely right that descriptively, there is a great deal of debate about and divergence of views on what constitutionalism is, and what its core is, and what it's supposed to achieve. But that exists not just across societies. That divergence also exists within societies, and even among scholars writing about the same field in the same country. So yes, there is a pluralism issue there, but that should not detract from those who are trying to make sense of a complicated practice, to spell out what they think the best understanding of it is, in order to see whether that is likely to gain acceptance, at least among a critical mass, to help change things.
May I ask a follow-up question? I'd like to say, what are your views about the United Nations, the way it goes about putting across its own concept of constitutionalism? It's always a Western constitutional order with rule of law, sort of based on the international financial institutions' prescriptions. So it's not a neutral rule of law. It's a rule of law with a hidden ideology. Do you have any comments on that?
Historically, it's always been the case, I think, that even those, or perhaps even in particular those, who use the language of rule of law, democracy, and human rights, have, this is the standard critique, have used under the surface of universalist aspirations. They've just promoted a very particular ideology that does injustice to others, and just impose it on it. So as a historical fact, a significant part of that is just true. Does that mean that it discredits this whole vocabulary? And the answer is no, it doesn't. And it doesn't because one of the remarkable differences, or one of the remarkable features of this type of vocabulary has been that it institutionalizes a critical justificatory discourse in which these types of biases can often, quite effectively over time, be addressed. So the understandings of these ideas and how to institutionalize them and what they mean with regard to respect of pluralism and engagement, that changes, that has changed, and that is likely to continue to change. But it's a hugely important resource for engaging in the right kind of critical reflection, in which the tension between universalism and particularism is itself a continuous topic. It never stops. There is no one resolution of it. Whenever there are those who claim that there is, then that becomes a problem. It's likely to degenerate into a new ideology. But the core part of it is that it institutionalizes a practice of justification of a certain kind, that operates within a universal frame that allows for communication of a certain kind, but is open to self-reform.
Well, I have a question. I mean, it's not really crystallized in my head yet, but you start your talk by talking about the way in which people theorists tend to think about the authority of states, meaning in terms of internal conditions, right? Then you name the rule of law, democracy, and human rights as being the main vectors around which that discourse is organized. Potentially add more, and then you say, well, we need to turn our gaze also to what exists outside states, a more external kind of validation realm. And you say that realm, these conditions, these external conditions of legitimacies, can be addressed or should be addressed by international law. You say international legal systems or the international legal system is what is required to to address these conditions. Right? I'm wondering whether that leap is not too quick between turning our gaze to the international realm and then say international law is what needs to do that work. Maybe we're just having a disagreement here about the meaning of law, what the international legal system is about, but it seems to me like that things like diplomacy, things about how states think of themselves, all these things, informal norms, all of these things are part of the securing of these external conditions.
Yeah.
Why go directly to international law and say that's what needs to fulfill that function, as opposed to international law and other things?
Well, what matters is that not that international law automatically has a concrete rule that resolves any of the externality issue, for example, takes a distinctive view on it, and that I certainly, with regard to many of the points that I've mentioned, I don't even have very well developed views on what an appropriate understanding of the legitimacy conditions actually are. Should there be a right to immigrate under certain qualified circumstances, and if so, how would you allocate the burdens between? I have no idea. That's very complicated. So the answer is not that international law needs to have the answers to all of these in the form of legal rules, but what it does need, what you do need, are procedures which allow for these types of questions to be addressed in the appropriate way. Now, that might in some instances mean diplomatic negotiations or even power politics, but it might also mean, in other circumstances, having procedures that are non-consensual that lead to an authoritative result. So I'm not saying a priori it has to be one or the other, but it might, in a very particular context, require a legal authoritative resolution of some kind.
So it's a proceduralist, cosmopolitan constitutional
Yes.
account. Okay.
Yeah.
I wonder if I could try and give a few more teeth to one of the original objections that you identified to international law, and skeptical objections, the realist objection. So what cosmopolitan constitutionalism asks us to do is to take a look at a couple of things. One, at structural deficiencies in the international legal system itself, or international legal order itself, but it also asks us to take a new look, or a critical look at domestic institutions as these relate to international issues, international structures. So I'm wondering then that, well, one of the institutions which seems to survive both state and non-state contexts is democracy, or democratic authorization. So if we're taking a cosmopolitan constitutionalist look at a domestic institution such as democracy, one of the examples you gave about how domestic institutions can present themselves as obstacles to international law was the U.S. Senate rule requiring 2/3 vote to ratify treaties. I'm wondering where that could be a bit more generalized, and suppose, well, maybe if we're thinking as realists, democracy at the national, at the state level, is an institutional obstacle. One of the ways in which it's difficult for powerful democracies to actually sign on to the right treaties or enforce human rights in the right way is that those sorts of international decisions, foreign policy decisions, would be very difficult to justify to a populace. Would be very difficult to get democratic authorization, or at least democratic authorization would be required. But there's some instances in which we'd want to say, well, as a state, as a powerful state, you just have an obligation to go in and help in a particular way, whether it's in terms of the environment or signing on to the International Criminal Court, for example, or doing something morally valuable. And what seems to be the obstacle for many powerful states is the very fact that they're democratic. Not that they just have particular ratification voting rules, but democracy itself makes it difficult for them to act in ways other than in their national interests. So I'm just wondering, here's how the objection might get more teeth. Wouldn't democracy itself be one of those institutions which would need to be rethought? And I'm just wondering if you think that's true, and how so, or how much so, would it need to be rethought from a perspective of a cosmopolitan constitutional perspective?
And you're right to point to the fact that there are circumstances under which democracy on a national level becomes a problem in the area of foreign affairs. Now, of course, it would be less of a problem if a state didn't have a veto. If you couldn't have the whole project of international legislation, authoritative resolution of an issue by the international legal system, be dependent on one or two powerful states. So that would then really be, it's only because the veto is the core problem. And if that veto is then exercised in a way that's sensitive to majoritarian concerns, that might make the problem more serious. But I wouldn't describe it as a problem of democracy. I would primarily say that's a problem of the power of the veto, the power of one state to prevent major shifts from occurring simply by not signing on to something. And of course, in practice, this is the way that legally this is trying to, there are attempts to circumvent this is by coming up with an idea of customary international law that effectively uses multilateral treaty making as an instrument to make rules binding on everyone. So if you have a multilateral treaty and it's signed by a critical mass of countries, sufficiently representative, then there will be international lawyers quite quickly that will claim that it actually turns out the content of the treaty is now customary international law and therefore also binding on those who did not sign and ratify the treaty. So that's one way of solving the problem. But what is interesting is that the moment something like that happens, the democracy argument is raised from the perspective of the country which is now bound, but didn't want to sign and ratify the treaty. Whereas within the cosmopolitan framework as I presented, it would actually be a solution to a problem that undercuts. So the solution to a systemic problem of international law that depends too much in a way that's no longer legitimate on the consent of a particular state. So democracy isn't the real problem. It's the veto of individual states that can be a problem. Now, there is something else, though, I want to say about democracy here. When we say democracy is important, I think there are no questions that when we talk about domestic decision-making within the state, about questions of policy, the way that we understand the principle of having an appropriate say will inevitably involve participation in elections and being able to throw the rascals out if need be, the government out if need be. So having genuine electoral politics. And it's also, I think, very plausible to claim that beyond the state there are all types of reasons why it's very difficult to institutionalize this type of politics. So whether you can do it in the European Union is at least open to contestation, but doing that on the level of the UN is not going to work for a wide range of reasons. So you're never going to have that, or at least we won't have that anytime soon, and probably for good reasons we won't have that anytime soon. And is that a problem? And the answer is, it isn't. At least it's not the case that there's something inherently superior about the domestic process, the outcomes produced by that process, when compared to the outcomes produced by say, a UN process. Let's look at a really bad process, the UN Security Council decision-making process. Now, that's a really terrible process. Why? Because you have 15 states only that have the authority with a qualified majority, 9 out of 15, to make basically binding rules. So the UN has developed the UN Security Council in some areas something close to a quasi-legislative practice. As a matter of fact, descriptively, this is simply true, in the context of anti-terrorism in particular. Requiring states to enact certain laws relating to the control of financial flows from their country to other countries, relating to the crimes they have to impose on people who fulfill certain requirements as aiding and abetting terrorism, etc. So you have the UN Security Council making these decisions, and you have these 15 states, and 5 of them have a veto power. So nothing ever gets done without the consent of those 5. And if you ask, well, which ones are those 5? Then you say, well, they're the ones that were kind of really powerful and important in 1945. And some of them still are quite important, and one of them is actually getting more and more important, China, now than it was. But why France and England are there instead of, say, the European Union having a seat, and why there is no South American state there, and why India or other Asian states, Japan, are not represented there. No African state is represented there. No plausible reasons in terms of justification. There's a historical account we can give, and then a public choice account we can give why we have that result, but that's not a good justification in constitutionalist terms. So we have a deeply problematic process, no doubt about it. Furthermore, there's not much deliberation going on. So let's say, nonetheless, that in this terrible process, in many ways terrible process, let's say the UN Security Council resolved the climate change issue. Nobody expected it because there's China, United States, etc., and Russia sitting on it. But let's say in some utopian world, somehow, those all of a sudden became the leaders in the call for doing something effective to stop climate change. So it now becomes possible, in terms of majorities, to move forward. And it turns out they decide on a radical, very aggressive set of measures to combat climate change through a UN Security Council resolution, which is binding on all states. Now, in many ways, we would say doesn't that raise very serious legitimacy concerns? And if you ask, well, should the UN Security Council be reformed, and should perhaps the General Assembly be involved in different ways, etc.? Yes, of course, all that would be much better, no question about it. But if we ask, is this solution, UN Security Council legislates, less legitimate than leaving it all up to states to make individual determinations, whether it's in their cost-benefit to sign up to climate change, effectively thereby precluding what is likely to be the majority of states from acting to actually have effective legislation, because important actors are kept out of it. So let's say those other states, the veto actors, they're democracies. They're liberal democracies, and they say it's not in our interest, we don't want to do this. Now, we have a conflict. We have national decisions relating to emissions made by liberal democratic states, let's assume, that say, well, we don't want this. We're better. It's tough. We know it's going to be tough, but it's better, all things considered, for us not to do anything, and then later on fight the consequences. And then there's a UN Security Council a decision which actually establishes a comprehensive regime for what's permitted and not permitted with regard to carbon dioxide emissions. And my claim would be that in terms of if there are legitimacy challenges in that kind of context, then the highly and deeply flawed UN Security Council quasi-legislative measure probably scores higher along the dimension of legitimacy than the decisions made by a minority of individual states that, in a democratic process, that preclude finding such an issue. And the core point here is a jurisdictional, a subsidiarity-oriented point. Democratic processes are simply not legitimate if those who participate in it are not in any way plausibly identical to those who are actually, in the relevant way, affected by the measure. So it's not enough. You can't just we can't just take a group of people. Let's say we here will now make a decision for all Canadians, and we'll make it democratically by voting and being very fair and procedurally. That's not right. We have those to whom we are ultimately accountable are those who are going to be affected in the right way by the decisions that we're making. And when it comes to climate change, no national process can claim any kind of legitimacy by itself, without coordinating, without immediately bringing in without reference to the participation of those who are going to be affected by this decision. So the result would be that a highly flawed, deeply problematic UN Security Council resolution probably has a higher level of legitimacy than a critical mass of liberal democracies who would veto such a measure.
Yeah, I could imagine you could read that in two ways. On the one hand, you could say that would be a correct decision for the UN Security Council to reach because it gets the right outcome. Yeah. Doesn't matter that it was reached democratically or not. Or you could say, well, that would be misunderstanding what democracy is. Democracy isn't really everyone's free and equal, but rather, and gets to vote, but rather everybody who's free and equal and affected gets to participate, which would be an explanation of subsidiarity in that case.
Right.
Yeah,
but it's important. It's not just outcomes. I mean, let's say that in this case, the climate change legislation is actually counterproductive. It's not very good. It doesn't target the right things, it's not effective, etc. But it's very costly, though, nonetheless. So let's take that case. I would still say it's significantly more legitimate, not because of the outcomes it achieves, but because of the participatory possibilities even this highly flawed procedure, in a comparative terms, offers when compared to just individual nations making their decisions. So so we still have 15, relatively, comparatively speaking. They're still from a wide range of continents, different countries, different cultures, coming together in a qualified majority, 9 out of 15, including 5 of the permanent members. They've agreed on something. That's significantly better. You get more participation, more accountability than absent such a decision.
So what if the decision taken by the UN Security Council is terrible? It's an awful decision.
Yeah.
Is there more legitimacy because there was this added level of participation, because the procedure was...
No, I'm not a procedural fetishist,
Okay.
so I don't think that procedure is a trump for everything, but it is an important consideration.
Right.
It's one important consideration. Outcome-related concerns, like rights violations or huge inefficiencies, are a countervailing concern.
Okay.
And we can imagine a decision that's just so fundamentally flawed that it would start to be legitimate, say, for courts and states, say, to simply say, look, these are de facto, for example, expropriations of corporations of the kind that under the circumstances are not susceptible to even a halfway reasonable justification, and we won't enforce that. So there's no trump. That's in the paper. I think I've developed that more clearly than in my oral presentation. There are procedural principles, there are outcome-related principles, and there are the jurisdictional principle of subsidiarity, which in some ways is connected to is still procedural. And then there's the idea of respect for legality. Once a decision has been made by the relatively higher, more inclusive community, then there's a prima facie case, but only a prima facie case, that decision should be respected, subject to countervailing concerns. If it was massively either procedural or outcome-related terms inappropriate, then there are good reasons to disregard it and set it aside locally.
Microphone, just a second.
If you can have some more.
Quick question. I was watching late TV yesterday, and I ended up on Fox News at 1 o'clock, and I know. But, I mean, the point of view shift from a globalist perspective to a cosmopolitan perspective, right? How would that, and again, moving back to the we the people concept, if you want to sell an idea, you have to convince the people. How would that mind shift or the shift in perspective address the Glenn Becks of the world? The Glenn Becks of the world.
I don't know why it should.
No, because yesterday I ended up watching it, and he was talking against the global perspective of trying to get a global union. And that simple shift in perspective may address that.
And if we now talk one of political strategy or tactical strategy or rhetorical strategy, and what I always do in the United States is I always quote the founders, who actually were deeply cosmopolitan in their outlook and in their understanding of how the Constitution, the American Constitution, fits into the wider legal world. So, for example, if you read the American Supremacy Clause, it quite remarkably says that the United States Constitution and all treaties made under its authority, and all laws only made pursuant to it, but all treaties made under the authority has the status of the supreme law of the land, equally to the Constitution. Now, in the history, American constitutional history, that has been, like so many things, has been read in a certain way and de-radicalized. Over time, dominant ideologies shape the way the constitutions are understood and how doctrine develops. But if we just take a snapshot and go to 1800, say, or even 1820, or when the document was drafted, as originalists say we should, but in this context where you end up quite remarkably is in a deeply cosmopolitan place. So rhetorically, I would suggest that Glenn Beck do some reading of the founders, but I don't know how that's all that illuminating.
The reason I'm asking is, at the end of the day, if you are proposing to shift, you have to also do the marketing.
Nope, I don't.
And in terms of marketing, you have to do with the populist, and obviously.
No, I suppose you can ask, what are the chances of this type of constitutionalism to find broad-based support? So with other words, you can criticize a theory which claims to be useful for reconstructing and guiding a political and legal practice, that it doesn't have a chance to resonate. That would, that's a ground. Not in if we did metaphysics here or mathematics, it would be completely irrelevant whether or not our ideas would be particularly persuasive. Einstein never had to worry about whether special or general relativity theory would be easily comprehensible by the man on the street. Just give him a couple of symbols.
It's a different matter, though, right?
So I'm interpreting your. So in that context, it really doesn't matter. It really doesn't matter that you. But I find it very plausible that when you're thinking about legal theories that claim to provide a normative framework for guiding and existing and understanding existing legal and political practices, particularly if we are not proposing a radically elitist theory, but one that is actually connected deeply to the tradition of the French and American revolutions, then the question of, if it's completely out of the question to be able to convince significant constituencies over time of these types of ideas, then it would be a flaw of the theory. So I think your objection is or your question is a perfectly valid one, even as a potential critique of the theory. But I have absolutely no. It doesn't seem implausible to me at all that an account of this type would not have good chances of resonating significantly under somewhat different circumstances. So I think one of the things we should be very careful about is to believe that just because things right now are the way they are, and discourse has a certain structure and political constituencies are in a certain way, that means that even 10 years from now, and forget about a time horizon of 20 or 30 years, we'll still be using the same vocabulary and fighting the same old battles. We might be in a completely different place. So when Kant was writing his critique of, or his metaphysics of morals, or his other more political writings on perpetual peace, he wasn't thinking, how would this sound in the eyes of the potentates of my day? So if I whispered this into the ear of the princes, would I have any chance? If I was their counselor, would I have any chance of them realistically right now dealing with that? Would this fit their way of thinking to a sufficient extent for it to be plausible to them? That's the wrong question to ask. That's the wrong time horizon to have, I think. So this type of enterprise is not written with the time horizon in minds of thousands of years. That's implausible for this type of reconstructive legal thinking. But it is written with a time horizon easily of between 5 and 25 years. And within such a time, I find there's nothing in here conceptually or in the kind of claims that it makes, which a priori would need to be implausible and would therefore be in principle rejectable, would have to be rejected by wide parts of the population. I think I don't think there's a special problem here.
We have one question here at the front, and then you. Just here.
I think my question maybe follows fairly well with the discussion we've just been having. That I noticed how often you use the word legitimation and justification without really being very explicit at all about to whom these things have to be legitimated or justified. And people like Einstein, the way they talk about law, they don't have to worry about that because they write the lawmakers out altogether. Because they if if what they thought was the law doesn't describe the phenomenon, they say, well, that wasn't the law. They don't ask why the atom wasn't doing what it was supposed to do, right? The law doesn't work in that sense. And in terms of the way, people in law schools tend to talk about law, we don't tend to study it in that way, although occasionally we do. But it isn't so much consent, I think, as acquiescence. That you're quite right to say that states, don't have perfect compliance with what they call the law. The example I usually give is, why would anybody think, observing the 401, which is a major highway through this city, that the speed limit was 100? The signs all say 100, but clearly that's not the law that everybody's behaving. They're operating under something quite different. But acquiescence is usually the key. I mean, a state can tolerate quite a lot of crime and even a certain amount of insurrection. But at a certain point, if other people have succeeded to a degree in delegitimating that state, well, then it isn't the state anymore. And that's why I'm, in terms of your theory, I'm not quite sure whether you're being scientific in that sense or whether you're being legal in that sense. And my question again at bottom is, why aren't you being more explicit about to whom things have to be legitimated?
But that's pretty straightforward. And laws always have to be legitimated for those who are bound by them or who are otherwise, through externalities, affected by them in the appropriate way. So we might have, with regard to the type of externalities that matter, there might be some interesting debates to be had. But in principle, in this abstract form, it's pretty easy to say to whom justification is due.
What's the name?
But it depends on what kind of, and we'd have to now, and just as the traffic laws relating to whether it's the 401, they have to be justified to those who are likely to. Actually, that's complicated because anybody might use it at some point. But it's fair to say that if that's a national street, right? It's a national. That's financed by the Canadian government and provincial government. Then presumably it will be the provincial people, the people of the province, not the provincial people, to whom it's justified. That if there are externalities that might be wrong, then they would have to be included as well. But this is the type of debate we'd have to have. By the way, if I may go back to that, it does mean that national constitutional rules relating to the law of foreign affairs, and perhaps also others, human rights, are very plausibly also have to be justified to outsiders, not just to the national constituency. So the idea of
to the extent that another country might invade and say, look, you're just illegitimate, we're coming in, we're doing things our way. I take it that's what you mean.
No, but not only those.
By it lacking legitimacy, is that it means that it basically the people who say they're in charge don't get their way.
Right, but also in the more mundane level, when we're talking about but other types of behavior that imposes negative. So these so all of these kinds of behavioral patterns give rise to concerns that these types of rules relating to the law of foreign affairs are supposed to somehow be related to and be helpful for addressing in some way or another. And so it becomes a concern of the outsiders. So the idea that the supremacy, first of all, the idea that there's an unqualified supremacy of the Constitution, even with regard to international law, is at least subject to challenge. It's not obviously the case. It doesn't mean that international law always trumps, but it means that we shouldn't take for granted the supremacy claim when it's being asserted not against different domestic laws, but against international law. That's a question mark right there. And the idea that the authority that the Constitution has is derived exclusively from national constituents, rather than also external constituents, who, for good reasons, if you think about major constitution-giving projects in the past 20 years, very often, typically, they involve outsiders also, because they have a legitimate interest, very often. So the idea of a constituent power that's only national is also a flawed idea, or a deeply problematic idea.
Thank you. I'd like to return to the interesting idea you had about democratic policies made by a single political unit like a state may lack a certain level of legitimacy if they're not taking into account the externalities on those people who are not part of that democratic process. My concern is that, given virtually any decision can be, portrayed as having externalities. I mean, you gave the example of making a national decision about global warming and climate change, but you could talk about immigration, you could talk about trade, pretty much any sort of national decision that's made. So if you construed, if I'm understanding you correctly, if you construe that idea too broadly, too forcefully to say, we have to take in the accounts of everyone who's affected, not just those who are part of the democratic constituency, that notion could be quite paralyzing. So I guess my question is there a principle or test for distinguishing those decisions democratically made, which do have externalities, but I guess have a threshold of legitimacy, versus those whose externalities prevent them from being regarded as truly legitimate?
A really good answer would be really, really long, because it would go into the theory of externalities and and the different kinds of externalities there are. But you're absolutely right. I mean, in some ways, the butterfly effect, what happens in one place will always somehow, through some kind of mechanism, affect everyone else in some other way. So the standard invocation. If there's a butterfly that flaps its wings in India, we might have a causal connection between that happening and a hurricane breaking loose. That's right. So if those kinds of effects are enough, then basically we just need everything to be decided by a global constituency in a global process, and there'll be nothing left for anyone, for local communities, be it on the state level or even smaller, to decide. So that can't be right. That's deeply counterintuitive and that is implausible. But I just to give you one idea of how one line, there are many issues here, but at least one example of how one line that needs to be drawn is, so in the example of climate change or nuclear reactors on the borders and this type of situations, we have, even though the concept itself is also highly contentious, but we have relatively straightforward ideas of harming outsiders. Think about other kinds of measures. Say, for example, we're dealing in a trade context. Let's say we don't have a trade regime for the time being. We don't have a trade regime. But let's say one country decides it's in its interest, the Red David Ricardo, and says it's an interest to have open borders, profit from comparative advantage, and we do lots of trade with everyone. We open our borders to everything. And then later on, let's say a neighboring state, over time, there are a significant group of producers which are targeting themselves and are relying on the market that they have in virtue of that policy in this state. And now that there's a political change, there's unemployment, there's populism, whatever it might be, but that state decides to change its policies and says, actually, we want to protect our producers. They're not doing that well. This comparative advantage stuff seems to be only a theoretical construct. In practice, it doesn't seem to go very well for us. And so they close the borders to these goods, and it has significant impact in the neighboring state, let's say. Significant impact. Now, this is serious impact, but it's an impact that's connected to opportunities provided by opening the borders. So it is an externality, at least according to, in the sense that it seriously affects the welfare of outsiders. But arguably, it's of a different kind, and is not action. It doesn't require the burden of justification. It doesn't require meeting the burden of justification of the other types of measure. Now, why that exactly is itself a complicated question. Requires. We can talk afterwards, perhaps. But these are the type. There are distinctions to be made here, and the result of these distinctions will be that certain types of things, certain types of externalities, give rise to significant duties of justification and counterclaims by the others that have to be respected in some ways, and there will be other effects you're not owed an explanation. It's like in relationships with people. There are many things that we do that affect others, but we don't owe everyone the same kind of an explanation just because their welfare is affected by our decisions. Now, we owe certain people for certain decisions certain types of justifications, but in other contexts, we don't. So, for example, if somebody else suffers greatly because you don't love them, say somebody is deeply in love with you, but you really don't really even like them all that much, there's not an issue. That person could not go to you and say, what's the justification? I have a claim in here, and certainly welfare is affected, significant externality, but it's not the type of externality that provides any grounds for involvement in how you think or how you make decisions relating to your own love life. So there are important distinctions to be drawn here.
Thanks, Mattias. It's a wonderful trend in scholarship on constitutionalism to turn to cosmopolitanism. And I guess I want to take you in a slightly different direction. You say within the paper a hazard or a risk with cosmopolitanism is its identification with a kind of individualistic bias. And in some sense, the pull of cosmopolitanism relies on that. So the idea of cosmopolitan right is very much presented by the attractiveness, the intuitive but also kind of moral attractiveness of the stranger presented in your midst, actually presented in your midst. And you can imagine this requires some kind of concrete response and some kind of concrete responsibility. And I guess part of the issue, the challenge that I want you to comment on is how well do you think cosmopolitanism will do in a global terrain that we have now, where the tiers that both pluralism and transnationalism identify seem to make the individualist and state divide far too simple in terms of thinking about principles both of human rights and subsidiarity. There is an element of, in some sense, individualism in there, and they play quite an important role in your vision of how constitutionalism might function. And so I guess I'm curious, I'm just curious what your thoughts about thinking about the constitutive and identity forming and crucially regulating aspects of other forms of groups, and whether there's a way to get around, or can you use the individualist aspect of cosmopolitanism to better address that? Yeah.
So to use the individualistic aspect of cosmopolitanism to better address the plurality of communities that we have, in fact, outside of the individual state.
In some sense, the contemporary global order, as opposed to the Kantian moment of reflection, is one in which, we can argue this, maybe that was also a moment of overlapping forms of organization and association. But I think most contemporary descriptions of the experience of the global life now is one that says, well, yes, there is this individualist element concretely presented to us all the time. And there is the state, and there are international and interstate kind of actors as well. But that the experience is actually much more of this kind of flux and this kind of movement. And I guess I'm just curious whether you think cosmopolitanism, not necessarily the individualistic side of it, but whether it has within it somehow the resources to address this, and how you would do that.
Absolutely. Now, the example that I give might be a little bit more ambiguous than this. So I should not, perhaps not even use that, but just I'll use it anyway. So in the European Union, on the occasion of the 50th anniversary of the European Union, a pronouncement was agreed upon by all the heads of state to describe what is special about the European Union. And the European Union is this, as many of you will know, this international institution, at least in the sense that it's based on treaties ratified by states, but it's so rich and such a thick form of a treaty, which allows for so many legislative acts to be performed that in many ways the European Union has quasi-federal structures, which is why many want to talk about it as a sui generis form of a polity rather than either a state, which it's not, or an international organization. But the point is that, so here member states come together and ask, what's special about this institution? And there's a lot of high-sounding, highfalutin rhetoric that crowds out a lot of real problems that exist in the European Union. But what was interesting is that it said, look, what is remarkable and different about this institution is that in the end, it's all about the individual. So that's the rhetoric. And then you look, well, what's been the effect of having a practice which fundamentally, I think, is plausibly described as fundamentally justificatorily individualistic. There's a lot of radical human dignity as the foundation rather than sovereignty. Now, whatever that means, first of all, it's symbolically and expressively. So it says we've now moved into a different justificatory universe that is individualistic. Now, in practice, what we've seen is that individuals haven't become more nomadic and radically alone creatures, but instead what we've had, and also legally recognized, so socially, politically formed, but also legally recognized, a greater plurality of communities. So instead of just, we have lots of decentralization movements in the European Union. Federalism has gotten stronger. We've had devolution of powers in many countries, so the UK, for example. We've had strong battles for asymmetric accommodation in Spain, for example, or gains of local communities in other ways. Minorities recognized that previously had not been recognized, minority rights struggles. So all of this greater pluralism of groups and communities has been, at the very least, supported by has been and is sustained by a culture of justification that is at its foundation is individualist. So that supports, I think, very much. I'm not sure whether I read your remarks in that way, but it suggests that there is the EU at least, notwithstanding, and there are also some, you could tell other stories about the EU in this regard, about suppression of difference, so I don't want to idealize it. But there are many central structural features that suggest that from moving away from sovereignty to a human dignity-based, individualist-based justice has helped sustain and create a culture where it's easier to recognize the plurality of groups and communities and identities that exist than you did previously. So an individualist, cosmopolitan, justificatory focus nicely goes together with a deep social, political, and legal pluralism.
Is there a possibility other than an individualist, cosmopolitan justification basis for your theory, or is there some other? I'm just genuinely interested whether within cosmopolitanism it must be an individualist.
No, ultimately, you wouldn't do.
Foundations.
I would be surprised if anything that claims to be an heir of of a commitment to an understanding of constitution that starts off just as a starting point of the idea of free and equals can be anything but individualist if it's not statist. I'm not sure. I can imagine other types of theories, of course, that perhaps make do without any foundations and are pluralist at the foundations. So there are lots of other possibilities, but to call them constitutional, I think, in that tradition would probably not make much sense.
Do you think that this movement towards cosmopolitanism is something that can happen gradually based on what we have now, some interaction between global civil society, international institutions, or do you think that it will take something more of a crisis to reconfigure the system, something on the scale of islands actually starting sinking out of the water? When we see major innovations in international law, they often follow major crises. I mean, San Francisco, Versailles, the European project only took off after the Second World War, so I was wondering what your thoughts are on that.
Yeah, well, there are gradualist evolutionary scenarios that would work exactly, looking at the type of mechanism that you described, international organizations supported by certain types of NGOs. Habermas has this idea that the national medias open up and cooperate, communicate more across national public spaces, etc. So that's one evolutionary trajectory that's at least possible. But I think for a real shift to occur, at least if you look at the history of these types of things, it's difficult to imagine a significant and powerful shift to occur without an external shock. And I hope that won't happen, and I hope the other trajectory will be powerful in and of itself. And it's not even clear that even if sometime in the future it might turn out to be hunky-dory and cosmopolitan, that in the meantime it would be so bad that in the end it's not clear whether it's going to be worth it. So I don't want to engage in any kind of progress narrative that's built into this at all, in fact. That's not what I'm trying to do. But I do think realistically that external shocks have played a hugely important role in bringing about significant conceptual and institutional and political shifts, and I think it's unlikely that it's going to be all that different in the future.
Yeah. If there are more questions, please join me in thanking Professor Kumm for a wonderful discussion and paper.